at a meeting this morning and I was asked to do the same thing. Let me oblige for this afternoon. Let us pray. Most righteous and heavenly Father, we thank you for life again. We thank you for bringing us here together to conduct the nation's work in a very important and critical matter. As it's usual, we ask for your guidance. We're asking you to take us through these proceedings. Give us the insights, the thoughts, as we proceed further. These we ask in your merciful name. Amen.
Amen. Thank you very much, Senator Gale. And are there any apologies for absence? No apologies. Okay. My welcome and opening remark. Yeah, sorry.
Yes, I have an apology from Mrs. Petrona Seeley Brown, the drafter from the Office of the Parliamentary Council. She's not well, so she can't attend, but she would try to join on, follow online.
Okay. All right. Thank you very much for that, SG. Okay. My remarks, welcome and opening remarks will be brief. Firstly, we've had a long break to get to since the last meeting, and it's not desirable because we really do need to bring this aspect of the legislative process to a close. The part of the reason, not the full reason, but part of the reason was for conversations to take place involving the critical players, the ministry personnel or consultant / advisor, the Office of the Attorney General, the SG, and her team, and then the wider consultation around some of the more controversial issues. A lot of that has taken place, and so I'm hoping that we will be in a position to proceed to bring this part of the process to a close, if not today, not too long from today. So I want to thank those of us who have been patient, and to the country, I say it is not a sign of our lack of commitment to this cause, but we're trying to get it right so that when it would have come for debate, or otherwise, there are no major issues to contend with and we can move forward. So this is the process of it being tedious. Hopefully, beyond this process, it will not be. All right, so having said that, I'm going to go into reading and confirmation of the last set of minutes, July 4th, 2023. And I ask you to join me in looking at these minutes. And I'll begin now with page 1 of 17, page 2, three, 4, 5, 6.
Chair?
Yes. Go ahead, member. Oh, Mr. Edwards, sorry.
Good afternoon, Chair. Yes. Just a technical point. On page 2, Ms. Wilkins is referred to as a director in the Legal Reform Department, but she's actually the director of Legal Reform. So just a technical correction there, in the interest of accuracy.
So the lead department. Okay.
Yes. Yes.
Right. Okay.
Thank you, Chair.
All right. So we're on page 6. Seven. 8. 9. 10. Page 11. 12. 13. 14. 15. 16. And finally, page 17 of 17 pages. Okay. Any corrections? No corrections. I see no hand up. Okay. And so I ask for the minutes to be confirmed. Move for confirmation.
Since there are no corrections, sir, I will approve and confirm these minutes.
And I will second, Mr. Chairman.
Okay, excellent. So Senator Gale and Senator Allen.
Allen.
Right. I need to remember to look up at the screen. Thank you. All right, any matters arising from the minutes? I see no hand up. Mr. Edwards' hand is up? No. Oh. Yeah, well, he hasn't, so I'm assuming. Huh? Right, so we're gonna go into the matters that are we needed to consult and then return. I don't know if Mr. Edwards wants to deal with those now or here, or we confirm with the understanding that those matters will be taken as an agenda item. Mr. Edwards, you want to guide us? Because there are a few, starting with 8, I think clause 8, right? Mr. Edwards, you want,
Yes, Chair, I think it's appropriate that they could be taken as agenda items.
Okay, so we'll minute that. So we'll confirm with no matters arising except the matters that we had agreed on last time for further consultation. So that means we can now move into those matters under new business, which is the continuation of the clause-by-clause analysis, but going back to clause 8 and then working our way to 24, where we would have stopped, where we can then move on from 24. So, Mr. Edwards, I'm going to allow you to take the floor to lead on this in keeping with the approach that we have taken. Just mention one by one, starting with 8, and then the members can chime in as appropriate.
Thank you very much. Thank you very much, Chair. So we have been examining the proposed revision of the proposed new provision of clause 8 dealing with limitation of interactions with the tobacco industry. And the document that had been recently circulated highlights the areas that would have been modified since the committee's last meeting. So if I may just look at the clause, the proposed clause, and we have highlighted the definition, the terms specified public official. I just wanted to indicate
Mr. Edwards,
to the committee.
Mr. Edwards, while I am very
yes, sir.
Yeah, sorry, I know there's a delay with this transmission of sound, but so sorry for the interruption. But while I appreciate the starting from the beginning, in the in the interest of full disclosure and transparency, to the extent that you can avoid going over what we have gone over already and going directly to what was requested to be reviewed, I think it's probably more time efficient. So if you have to, fine, but if you don't have to, just go right to the point, because we're assuming that we all are aware of what we have been discussing. Yes.
Okay.
The summary sheet and
All right,
one dated
Chair,
November 27th. I just want to know which one we are working with and which one we should follow Mr. Edwards on.
But I'm going with the summary sheet.
The summary sheet?
Yes.
But there's a document that we would have received dated November 27th that would have it says revised provisional extracts from the tobacco control bill showing this is the one showing the decisions which suggested text developed by the Ministry of Health and Wellness.
Right. So that would have been incorporated in the summary sheet.
In the summary sheet.
No?
Yeah, the intention, if I may, Chair.
Yes, go ahead, Mr. Edwards. Just clarify that for us, please.
The intention, following on Senator Gale, the intention is that the sheet that was circulated dated November the 27th can be read in conjunction with the summary sheet, because we have sought to reflect the decisions indicated by the summary sheet in this document, which is an update of suggested text meant to reflect the decisions to date of the committee. So the document of the 27th of November is really the latest reflection from the ministry of how we have interpreted the decisions as stated in the summary sheet.
Thanks.
Okay.
So we have sought to reflect.
That's okay. That's okay.
Okay, fine. All right, Mr. Edwards, I think you have clarified. Thank you for that. So go right ahead, and sorry for the interruption.
Not a problem, Chair. So I think the main thing to point out in relation to clause 8 is that members will note that there is no longer an offense. This is no longer an offense creating provision. It is now a provision that is proposing duties on officials, but it is not creating an offense, and it is also no longer proposing a direct link between the activities specified in this clause and the disciplinary proceedings or proceedings under public service regulation. So that's the main change. It is now proposing a set of duties to be imposed on specified public officials, but it is not creating any offense, no direct offense for non-compliance. So therefore, it will be up to the persons who are in charge, who have authority over the officials who may have not complied with these provisions, to determine what to be an appropriate response, likely disciplinary or departmental sanction in relation to persons who have not complied with this provision. But it's no longer an offense creating provision, and it is also no longer making a direct link to the public service regulation. So that's the main change that has emanated since the last meeting of the committee.
Yes, Mr. Edwards, hold on. Member Gale.
Whilst Mr. Edwards would have highlighted the specific difference in approach, being one now that appears to be guidelines, but I'm reading in conjunction with the area that speaks to 9, A breach of any other provisions in this section by a specified public official constitutes grounds for disciplinary proceedings.
That's a different provision. I was just focusing, as Chair had asked, going step by step. So this is clause 8 I'm dealing with.
Okay. All right.
Okay, as the
clause 8
doctor,
is the one that is...
one second, Mr. Edwards. Dr. Guy, you have your hand up. You want to come in now, please?
Thank you very much, Chair. I was asking a question based on the same line that Senator Gale was asking, because my concern was, what are these disciplinary provisions that are being contemplated? Because we have to ensure that the disciplinary, whatever disciplinary provisions that we are making are appropriate for the infraction that has been committed. But I'll await Mr. Edwards when we get to there.
Yeah, I was about to say it. So we're going to work it, in a stage by stage.
Okay, so Chair, has the committee completed consideration of clause 8, or is it that the committee wishes to interlink clause 8 and clause 9? Because they are rather distinct provisions.
What are you recommending? That's what we're considering. So just recommend what you recommend.
Well, it would be good if we could hear specifically about clause 8, because clause 8 is really the one dealing with the public official and the interaction and the process by which the individual may interact with the industry. Whereas clause 9 is a much broader one, dealing with conflict of interest and conflicting arrangements.
Right. So, Mr. Edwards, I'm saying take it one at a time and just start with where you are and then move to the next one. If there's a conflict of some kind or need for some complementarity, then we'll chime in at that time. But just start at the beginning.
Well, I have given a summary of clause 8 in relation to the changes. I believe the members are familiar with the terms, and we really haven't changed the substance of the clause.
Right. So what I'd ask is the committee agreeing to this revised clause? That I think is the question at this point. If there are any objections or suggestions by anyone, can you speak now? Otherwise, we move on to the next.
No objections from me, Chair. Senator Longmore here.
Okay. All right. So, Mr. Edwards, you want to read it, and so it's read into the minutes, if you will, or can we assume that it's accepted? Sure. Go ahead.
So clause subsection 1 speaks to a specified public body or specified public official shall only participate in interactions with the tobacco industry to the extent strictly necessary for effective tobacco control and enforcement of relevant laws. And I should indicate that the specified public body and specified public official are really the persons who are the entities that have specific responsibility in relation to public health policy for tobacco control and are not the general public service. 2, a specified public official shall not participate in any interaction consisting of a meeting with the tobacco industry, except in joint participation with at least one other specified public official. 3, before commencing any interaction with the tobacco industry, a specified public official shall state in writing to the appropriate authority within the specified public body that the specified public official is employed or engaged within, that the interaction does not imply an endorsement of tobacco industry practices, and that no relationship, collaboration, or partnership whatsoever shall be construed as arising from the interaction. 4, a specified public official participating in any interaction with the tobacco industry Is there a request, Chair?
No, go ahead. Go ahead.
I thought, okay. 4, a specified public official participating in any interaction with the tobacco industry shall prepare a formal record of the interaction and submit it to the specified public body that the specified public official is employed or engaged within, and on request to the appropriate authority. 5, a specified
Hold on,
public
Mr.
body
Edwards. Hold on.
initiates and
Sorry, Mr. Edwards, I just wanted a clarity there in terms of the prepare a formal record. Is that indicating that there is some format, prescribed format, that is allowable, or just a report on the matter will suffice?
Well, at this point, to you, Chair, to Senator Gale, at this point, there is no specified format proposed, but it is customary that matters like this could become the subject of regulations or directives that will detail the processes that should take place. But right now, there is no specified format proposed.
I would want to suggest that we contemplate that approach so that, for the, it provides a kind of homogeneous approach towards doing so, or a standardized approach towards doing so. So we may want to contemplate taking that on board. Thank you, Chair.
That would be very useful. That would be very useful. And normally we could refer to something like a prescribed form, but we didn't want to get into that level of detail yet. At this point, we really wanted to hear from the committee a broad response in terms of the principles. So those are details as to how the process should be operated.
Okay. Yeah.
So it's likely that could be developed on the regulations.
All right. So note that, and let's.
Sorry, Chair, and I do apologize because I don't have a camera. I have a defective webcam. I'm hoping you're hearing me though.
Yes, we are.
Oh, okay. And I hope it stays that way. Chair, I feel compelled to say this again, although I think I've said it before in previous discussions. But as these amendments have been set out, I want to just understand what we're asking public officials in presumably the Ministry of Health to do as a matter of engagement of their work. We're asking them that whenever they engage or they're to have a meeting or some interaction with someone in the tobacco industry, that they must sit and fill out a form and send it to their supervisor. Is that ultimately what we're asking them to do? I don't know if,
Mr. Edwards?
May I respond?
Yes, please. I'll come in after.
Yes, thanks. Well, actually, what we're asking is at the other end. It's really a record after. It's not like saying you're asking them to prepare a form, asking for permission before. It's really like minute taking. It's really asking them for the record to indicate what happened between them and the representative of the tobacco industry. So it's a record after the event, not something like seeking permission before.
Yeah, but so clause 3, Mr. Edwards, says that before they.
I thought it was something.
I'm talking about.
Looking at. Sorry.
Yeah, we are looking at 4, but 4 in conjunction with 3 is what is concerning to me. So before they interact with the tobacco industry, they're to state in writing to the appropriate authority, whether it is a prescribed form or something else, within the very body that is likely to be the body that has directed them to interact. I'm really not understanding this as a way of fixing the concerns that we have. I see it as very bureaucratic, and I can't see how the very busy public officials in the Ministry of Health who have difficulty sometimes just responding to the volume of emails and calls that they get. I just don't see this as being practical.
Can I come in? Can I come in?
If I may,
Mr. Edwards, let me just. So, I mean, bureaucracy is a part of us, and I don't know if we can use the fact that we are likely to be occupied with other matters that involves procedures to justify not establishing certain procedures in this case. If anything, we can lobby for more people to assist the process. What I think this is attempting to achieve is a transparent approach to dealing with what we have all considered, expert advice and otherwise, to be one of the most dangerous vices that one can engage in, where various approaches have been used to preserve and to promote that particular practice. Now, you can't stop someone clearly from bumping up into someone on the street, at a party, at a golf course, and having a conversation. And indeed, if they want to hide it, they can do it in a private room. But that applies to all sorts of conflicts of interest that can be defined and would not justify us not having a procedure. In this instance, the procedure ought to be perhaps even more bureaucratic than in other cases, because of what we all have concluded is a practice that has caused significant harm to society as a whole. And, you know, we need to look at some of the benchmark activities that exist around the world around this particular legislation or the approach to this particular type of legislation. Because we have to accept that it is unusual, or should I say unusually strict. It's not a Jamaica thing, it's a global thing. I mean, there are even countries now that are promulgating the total ban of smoking. We're not there, clearly. So, you know, I think we run a risk of trying to apply a principle or a set of rules that may be standard in controlling activities generally, when in fact the rules as applied to tobacco consumption based on the scientific conclusion of its adverse impact is a much higher standard of oversight and supervision. And we need to adjust our, I say respectfully of course, our mindset to that recognition, which is not unique to us. It is the case right across the world, right across the length and breadth of the world. So I'm saying that because we know we have to deal with what is a legal product, and we know that a big part of our responsibility is to protect the society and as best as possible to restrict consumption in a way that encourages consumption otherwise, whether first hand or second hand. And we know the vulnerabilities around how the process can be manipulated, because we have seen evidence of that. We have to add layers of bureaucracy that attempts to control, and no system is perfect, but at least attempts to control. And as a result of that, I see no reason why a public official who is responsible for regulating, who has to deal with this situation, from logging the extent to which they are engaged in that regulation. Absolutely no reason why we can't do that.
Mr. Chairman, I think you misunderstood me, because I wasn't taking issue with that particular clause. I was really, as Mr. Edwards was reading that one, I was really harkening my mind back to the previous subclause, because because what we're saying is, I'm the boss. I direct you to have an interaction, and then as some sort of bureaucratic step, I then ask you to write back to me to tell me that you're having that interaction, and that it's not, you know,
but with due respect,
no, let me finish, please.
Yes.
It's not an interaction that offends the act. it's a little absurd, that clause, that subclause 3. I'm not taking issue with the reporting of the interaction. I'm taking issue with the permission part, when in fact the interaction is directed by the very appropriate authority.
All right, tell you what, maybe we should ask the PAHO rep to comment on how standard this practice is here and elsewhere, not here. Would you like to give us a kind of overview? Because I think we may benefit from what the existing precedent is.
And if he could also speak to my concern about the absurdity of it, because I as a thinking brain, I really, international practices may be international practices, but we really have to think about the practicality of it in our own scenario and really whether or not something makes sense. There are lots of international practices
that's what
that
I've
don't
asked.
make sense.
That's what I've asked her to comment on. So, can you?
Are you hearing me? Oh, yes. Sorry, and thank you very much, Chair. Just to weigh in, so the provision that we have or that we're seeing in Jamaica's in the bill, it is also similar in Kenya's current regulations. In fact, I'm currently looking at section 22, subsection 4, which is almost the exact replica, where we're seeing it says any public officer participating in any interaction with the tobacco industry shall prepare a formal record of the interaction and submit to the relevant public authorities. I recognize, however, from Member Gale's intervention earlier, the need for there to be a standardized document, perhaps in the regulations. And in consideration of the point that was just raised, well, before I move from Kenya, we are also looking at Uganda, and there's a similar provision in Uganda's legislation. So that is just a name too. So
Mr.
by
Chairman,
no
I'm
means.
so sorry, I have to interrupt. We're not talking about the same thing. We're
No,
talking
I'm coming
about
to your point.
two different things.
Right, I'm coming to your point. So to go to your point about whether or not there is to be permission prior, that is something that we can look at. However, so far I'm just informing on the declaration about the ministry representative or the public official declaring. This is a part of Article 5.3. This is also a part of the guidelines for implementation of that treaty, which speaks to transparency. In terms of transparency, any requirement that there be a declaration prior to the meeting is also something that is outlined in the guidelines. I can locate other legislation, or I can do a search for other legislation, Commonwealth, which might be more relevant to our particular setting, and give particular indication as to whether or not there is a similar requirement for you to report prior. But what the position is certainly from PAHO is that even if the requirement is there for them to disclose prior, it's still a part of the transparency that is required under Article 5.3. And I am of the view that it is not impracticable or impractical for that to be.
Mr. Edwards, you want to come in on that as a follow-on, and then we'll go to Member Daly.
If I may, thank you. If I may, Chair, thank you very much.
Dr. Guy, and then Member Daly.
And yes, and I can appreciate the concern of Senator Bowling Campbell in terms of ensuring that our, public or public activities, public sector activities are run in an efficient, effective, and sensible manner. So something like this is probably going to end up as what we call a standard form. So there'll probably be developed a standard form which has almost like a footnote with the information that now appears in the law in subsection 3. So just like how in our emails we've become accustomed to a standard footnote declaring that if you wrongly receive this, you should not disclose it, you should return or whatever. Then we expect that it's likely that this is going to be something that the individual officer does not actually have to make a specific determination of in each case, but is going to be basically built into a notification of meeting form, for want of a better description. Thank you, Chair.
Thank you. Member Guy, and then
Thank you, Chair. I was thinking along the same lines because, quite frankly, I did not understand what my colleague senator wanted, my colleague member, the senator wanted out of this. Because my interpretation of it was that, okay, to avoid any conflict or any suggestion of secrecy, that particular specified public officer would complete, as Mr. Edwards said, and I was thinking along that lines, a form to say, I'm meeting John Brown of X Tobacco Company today to have a discussion, etc. After he meets that particular individual from the tobacco industry, he prepares a formal report. I cannot see why there ought to be a conflict in terms of that, unless I'm not appreciating what my colleague member on the committee is asking for.
thank you. Member Denise Daly.
All right, just quickly, Chairman, I'm very sorry to be late. I didn't know you was on Zoom, or else I would have opted for the Zoom. However, I want to know specifically who are the public officials are you talking about? Is everybody? Because that needs to be clarified, because you don't want, all right, take for instance, Carreras, who was in St. Catherine, in northeastern St. Catherine, and there's a football competition, and I meet with them and something is given as a donation. I would end up finding myself being questioned and probably being punished too.
Well, the law deals with that as a separate issue, so that would be addressed. But Mr. Edwards, maybe you can clarify it does define the specified public official, so it's not every public official. But there's another aspect of it around promotion and so on, which is why I say so Mr. Edwards probably can comment on that. But while we do that, can we agree then to proceed with the clause as stated, recognizing that a requirement for reporting, even though it may be tedious, as said by Senator Golden Campbell, does add to the levels of transparency, accountability, and that may be necessary, that would be necessary in this case. I'm discerning that that's a general consensus, maybe with one dissension. Hopefully Senator Golden Campbell will appreciate what is being said. All right, Mr. Edwards, you want to continue while addressing the public official issue, which I think we have addressed before, but you may want to just quickly address it again for
Senator Daly's yes, of course. So first of all, of course, the whole legislation is proposing a new paradigm where there's much more control in terms of relationships between officials and the tobacco industry. In this case, Clause 8 is speaking to officials who have functions that relate to development of public health policy with respect to tobacco control. So it's not the general public servant we're talking about, or those who have roles that are really very related to tobacco control issues. So it's not the broad public official or public officer that is being addressed in this case. And if I may also comment on this issue of the record keeping, I believe that many public officials, public officers would welcome this in the new paradigm being proposed in relation to tobacco control, because it actually can end up being a protection for the public officer if down the road any questions are asked, that they have actually recorded the nature of the activity or the interaction. So it actually provides protection for the public official too. Thank you, Chair.
Okay. Can you continue then, please?
Well, in Clause 8, so we were at subsection 4, which is the one speaking to the formal record, and then I could move to subsection 5, which states that a specified public body that initiates an interaction with the tobacco industry shall ensure as far as practicable that the interaction takes place only in a public venue determined by the specified public body. 6, interactions with the tobacco industry shall not take place within offices or other facilities of the tobacco industry except where necessary in the course of the enforcement functions of authorized officers. And if I may just indicate that those words were highlighted in the sheet that was circulated because the intention was to link the persons who would be involved in enforcement to the officers specified in the legislation as authorized officers, so that there is a direct link between the persons who will be carrying out the enforcement functions, and we would be going beyond those specified authorized officers under the Act. 7, a specified public body shall not, and again, we're indicating that this is being targeted at the entity that is directly related to public health policy for tobacco control and not every public sector entity. A specified public body shall not A, accept any direct or indirect funding from the tobacco industry or enter into
Mr. Edwards, Mr. Edwards, sorry,
yes,
can you just move to 9, please, and just focus on the ones that we highlighted and I think we're repeating ourselves by going through what has already been agreed on, if you don't mind.
Chair.
Sorry to seem impatient, but...
Chair.
Yes, member guy.
Thank you. Just before we go, a point of just clarification. Why have we moved from specified public official and 4 to a specified public body in 5, 6, and 7? Just for my personal edification.
I think we're dealing with a separate... Mr. Edwards, you want to just clarify that quickly for me, please?
Yes. 4, 5, and 6 are a control on the entity as opposed to the official, and we're not putting a duty on a particular official in relation to establishing meeting venues and so on. So we're putting it on the body that the official is employed in or engaged in, as opposed to the official.
Thank you.
Mr. Edwards, just to encourage you to go to the sections where the adjustments were recommended. We don't need to repeat what is already agreed on. Okay? Please.
Sorry, Chair, I was doing the whole provision.
Thank you.
Okay. So clause 9, the relevant
hold on, Mr. Edwards. Senator Golden Campbell has a point. Go ahead, Senator.
I'm sorry. I am kind of taking you back a little bit, and I apologize for that. I have a question, though. In a scenario where a public official seeks this permission in writing to interact with the tobacco industry and makes this declaration, and that interaction does not happen, what happens to that prescribed form when it is not matched up with a declaration that the meeting happened? And please understand the lens from which I'm speaking of, because we have a thing called the Integrity Commission, right? Who no doubt would have carriage over matters like this. And if I were the director of whatever it is, the office is now, I would be concerned that I have a form that you were to have a meeting, but now I don't see a declaration that you actually had the meeting. What happens? Can I retract the fact that I asked for permission?
No, but isn't it logical that if a meeting is approved to be had and it doesn't take place, a follow-up report says meeting never took place, maybe because X, Y, Z, And
we haven't made
I
a
don't know why
prescription
that,
for that then.
wouldn't that be a kind of logical sequence of events as opposed to a withdrawal of an approval? The fact that
Yes,
you,
sure, but what I'm saying is if you're prescribing that, you must have the form to ask the permission, and you're prescribing that you must have the form for asking for the declaration, then the declaration of what happened at the meeting and that you had the meeting. I'm just saying there needs to be something that says, well, I did ask for permission, but I didn't actually have this meeting.
yeah, but remember, I hear you. What I'm saying is, if I was slated to, anyway, let me not use my example, but I would imagine that the form would be submitted with a very succinct note that for whatever reason the meeting didn't take place, and that could be validated one way or the other. I don't know if any other legal members, you want to comment, Ms. Birch?
I wanted to clarify that for subsection 3, what is required is a declaration. So what we're seeking is to have this specified public official declare before meeting, and also at 4 to make a record of what happened within that meeting. So it's not that they're seeking permission beforehand. And that goes in line with what my colleague said in terms of having transparency, to say we will be meeting for whatever reason, and then afterwards we have met, and this is what we met on for the record.
Yes, but if we don't meet, because you have specified all of that, if we don't meet, there is nothing that I can do as a public official to put on record that the meeting didn't happen. So if you're putting in law that you must do a declaration in 3, and you must do a declaration of the meeting that happened in 4, then there needs to be a provision for situation where the meeting doesn't actually happen. You cannot leave that up to logical conclusion, because you have authorities who are going to be looking at the paperwork, and you've put in law that certain paperwork must be in place.
I must admit I'm not a lawyer, or maybe I'm a common law lawyer, but or try to be. But I just think that a kind of rational response or logical response, if a meeting doesn't take place, would be to place on the form that the meeting didn't take place. I mean, is there the need for an amendment to the legislation to say if the meeting doesn't take place, you must put on the form that the meeting doesn't take place? What's the view, Mr. Edwards? I mean. Huh?
If I may, I see Senator Longmore. I will yield to Senator Longmore.
Thank you, Chair. Just I'm just quickly of the thinking of yourself, Chair. I would think, but again, we're not legal minds. I would think that if there is a provision for a report of the said meeting to be had, if the meeting was not had, then the report would reflect such that the meeting was not had. So I don't think there needs to be a further, I don't know, like I said, if there's a legal requirement, but the report would indicate that the meeting was not had subsequent to X, Y, and Z reasons. Thank you, Chair.
Mr. Edwards, you want to give your opinion?
Chair, I was just going to say that this goes back to the earlier discussion arising from Senator Gale's comments earlier, where we were saying that some of these matters can be addressed in guidelines or regulations. These detailed steps that may give comfort can be put in regulations or guidance notes.
I would be grateful for that, Mr. Edwards, because oversight bodies are not given to, if you have paperwork, they're following paperwork. So it needs to state it.
Okay.
Yes,
all
so
right.
The procedural steps
can you note that? I mean, to me, that's kind of out of an abundance of caution. I'm not so sure it's necessary, but I take the advice from a legal mind, because I am not, and that includes you, Mr. Edwards. So let's proceed then, and you make a note of that. But otherwise, I think we
Chair, in
can
clause
proceed.
9. Yes.
Yeah.
Thank you, Chair. So in clause 9, we're looking at the whole issue of conflict of interest. I just want to point out that in relation to 9.1, The substance remains. It was a rearrangement of the text for purposes of elegance. It wasn't a change of policy being reflected. So if members, if it's clear, I don't need to read subsection 1. We had just restructured it in the interest of clarity. Okay. I will just indicate, however, in the marginal note that some words are highlighted there because we thought it necessary to indicate that this provision, yes, it is a conflict of interest generally, but we wanted to specify that it was conflicts in relation to certain arrangements or engagements between public officials and the tobacco industry. The next area of any adjustment, let me just get to it quickly, because we didn't really make much adjustment in this. Yes, would be towards the end of this clause where we speak to the question of the commission. Well, a decision had to be made as to whether this whole provision should be an offense creating provision, attracting a criminal penalty, or not. So we put the option.
Where are you exactly?
Either,
where are you, Mr. Edwards?
Penalty.
Just tell us where you are exactly.
I'm at the end of clause 9, subsection 9 of clause 9, the end of clause 9, Chair.
Okay, so guide us that with the numbers, please. Okay.
So this is the only other adjustment to give an option for the committee to consider whether first of all, whether this sanction for breaching these provisions should be of a criminal nature or whether there should be a civil penalty. So that's the significant change that we have put in this provision. And we have also done some research in relation to conflict of interest provisions in a number of countries. I mean, there are a number of countries where conflict of interest, similar provisions in relation to tobacco control attract a criminal penalty. But we were very conscious of the previous discussions in the committee and the guidance of the Solicitor General. So we have put the option for the committee to consider whether this provision should attract a criminal penalty or whether it should be a civil administrative type penalty. As appears in legislation such as the Building Act, there are a number of pieces of legislation where civil approaches for sanction are adopted. So that's the matter for.
So basically, you have no recommendation. You don't have a recommendation.
The first recommendation from the ministry is that there should be a sanction.
Yes.
The question really is whether it should be a criminal sanction or a civil penalty.
Mr. Chairman.
Yes.
Clause 9 again was I know we had hot debate on clause 9. Clause 9 is read as almost a strict liability type of clause. An individual who has an interest, whether of a pecuniary or business nature. I ask again, as I have done before, what happens to the individual who invests in mutual funds that are invested in the tobacco industry and doesn't actually know that they're investing in the tobacco industry? That person doesn't know, but yet they're required to disclose something that they don't know. So either if we're going to sanction this, there has to be an element of knowledge.
Mr. Edwards?
Yes, so Chair, I just want to be clear which aspect of the provision our Senator is referring to. Is it subsection 5, which speaks to making declaration of interest? Is it subsection 5
No,
particular?
we're at 9, right?
9.5.
Right. So at 9.1,
Subsection 5.
at 9.1, you have a person who has an interest, whether of a pecuniary or business nature, must disclose the nature of the interest to the public body. And you go down in 4, 5, sorry, I'm scrolling. You go down now to 9, subsection 9, and you say a person who contravenes subsection 1, which is the first bit there, commits an offense. And we're now discussing whether or not that's a criminal offense or a disciplinary action or sanction. And I'm saying in 9.1, if you're going to sanction that, there has to be an element of knowledge. I cannot be liable for criminal prosecution from something that I don't know.
Criminal prosecution or civil penalty, because we're
Regardless
saying,
of what
okay.
the penalty is.
Can
I must
take
know
it?
that I have that interest.
Can we take it
Sure,
in stages, please,
yes.
members? Mr. Edwards, you were dealing with a particular point, and then we introduced a new point. We need to decide whether what the measures are. Are we agreed that it is punitive to criminal or otherwise? Is there an opinion in the room on that?
But Chairman, the point I'm making is relevant to making that decision.
Well,
and if I may, Chair, if I may respond directly to the concerns of Senator Golding Campbell, because it seems that, may I, Chair?
Go ahead.
Yes, it seems as if the concerns of Senator Golding Campbell would relate to the question of whether a provision needs to be made for defenses. You know, provisions like this can be crafted in such a way that defense can be had if certain circumstances exist. So what the senator is referring to is circumstances where there is not actual knowledge. And if it's that the committee is minded that, especially if one is looking to sanction infractions against this provision, then it seems as if the committee may be asking for a defense provision, meaning that if there is actual lack of knowledge or other circumstances that would seem to make it unjust for somebody to be punished in.
But what does the law say no about knowledge of particular laws basically? What is the if you breach a particular law and you are taken to court, can your defense be that you weren't aware and therefore you should be given pardon or a lesser sentence, or what's the current position on that? And why is it different in terms of tobacco legislation as opposed to other laws that currently exist? I thought my understanding was that ignorance of the law is no excuse. Isn't that the principle? I mean, I don't know. I need to be
ignorance of the law. I mean, but it depends on what the law states. So there are different forms in which the knowledge element can be crafted. So, you know, I think Senator Golding Campbell referred to strict liability. So strict liability offenses, you don't have to prove specifically the knowledge element that the person intentionally, or, you know, that they are knowingly, those types of...
But the point I'm making is, and I'm coming to you, Ms. Birch, if a law is promulgated that says you should declare if you're invested in this particular area, those who are selling that investment in the first instance, I think, has an obligation to outline to those who are tempted, encouraged, motivated to invest, to say this is what the rules are for investing. It includes this. And in effect, maybe they would, that's a kind of duty that they would have because of what the law says. Assuming that that doesn't take place, the buyer also has to be aware if the law specifies a particular process to investing and would need to educate or inform themselves. Assuming that that doesn't happen, isn't there a sort of universal principle that ignorance is not an excuse? I seek some advice on that. Ms. Birch, you wanted to come in. Hold on a second, Ms. Edwards. Ms. Birch?
I'll yield to the Solicitor General. Oh, Ms. Birch, okay.
Just before the Solicitor General, what, Ms. Birch?
Take the point from Member Golding in terms of if the person is not. I do take the point from Member Golding in terms of clause 9.1 and just reviewing it. We could consider whether to address the issue, whether we insert an individual who is aware that he or she has an interest, shall, and go on to say shall disclose.
But why would you do that? Isn't that creating a loophole in the law where the very obvious response is going to be that I wasn't aware, even if I were? Or should it be a duty on your part to be aware? If we have laws that are public and knowledge that the law exists around this particular industry, I would prefer to say insert something that says those who are involved in this process should make it should make it known. In other words, if you're selling investment and it involves tobacco, then why not say that right now, if you know, I am advised by my broker what they're investing in. I don't know if that is a standard procedure across the board. If they're selling some stocks and buying some others, they send me a notification. I can say no if I want. So, you know, to say, if you are aware, suggests to me a very easy out to say I was not aware. I mean, why would we want to do that? To create that kind of loophole? I'm not sure. Yes, Mr. Edwards. I see member Guy's hand up, and then Mr. Edwards.
Thank you very much, Chair. I think in our discussions, we are somewhat not seeing the point that the Senator is making. She mentioned specifically and cited the example of a mutual fund, which if you invest in one, you have no idea what the investors will be investing in. So the concern that she has is a real concern, and it's a concern that legislation may need to be promulgated to cover. In that, it's either you know or you don't know. But the example you cited, Chair, is a different example, because I mean that is where you have shares that your investor will decide to get rid of and invest in something else that might yield better returns. But a mutual fund is one where the investor of the entity that you invest the fund in will put the funds any and everywhere. So either you are aware or you're not aware, but I don't think you should be penalized for not knowing in this particular instance.
I am not suggesting that you should be penalized for not knowing, even though that may end up there. I am suggesting that the procedure should be structured in a way to make it an obligation for that knowledge to exist in the first instance. So if you're investing in that instrument that involves a tobacco interest, then that is known to who is the investor. That was where my mind was at. Mr. Edwards, you want to come in? You had your hand up.
Yes, thank you, Chair. Thank you. And following on from my colleague, Ms. Birch, just to indicate, to remind us that awareness is really the central element of subsection 1, because it is only if the person becomes aware or would reasonably be expected to be aware of the holding that the issue of any sanction for contravention would arise. So the element of awareness was contemplated in the crafting of this provision. So if it is that there are other aspects of awareness that need to be addressed, then we are prepared to consider such. But the awareness element was at the heart of why in subsection 1 we do speak to when the official becomes aware or would reasonably be expected. So in a mutual fund, as Senator Guy as Member Guy has indicated, that would be a hit or miss situation. The person may really not have been aware that their funds were being so invested. So awareness is at the heart of this provision.
Mr. Chairman, with respect, that is not the draft that I'm seeing in front of me. There is no element of awareness in 9.1. There's absolutely no element of awareness. If I have an interest, whether I know it or not, I'm being required to disclose it on commencement of employment and other things. If awareness is contemplated, then awareness needs to be drafted into 9.1. It's not there now.
I'm not looking at the same. I'm so sorry.
No, 9.1b says being a public official, as soon as a public official becomes aware or would be reasonably expected to be aware of the holding of the interest. So it's actually part of the amendment, right, Mr. Edwards?
Then 9.1a needs to be correct, because 9.1a doesn't say that.
Well, 9.1b does.
9.1a is upon commencement. Yes, so 8b is dealing with the existing official staff member, etc. A is a new person coming in. The ministry is prepared to recraft to ensure that this issue of awareness applies to both the person coming in and the person already employed.
Is that clear?
Thank you, Chair.
Chairman, it's very important what Senator Golden, I'm just saying Senator Golden for the time being because I am not so privy with the other name. But just to state that 9.1 is very important because you're also looking at a sanction. And the sanction that you're looking at is even to criminalize the person. So you have to make sure that they are fully aware.
Yes, but I'm saying the revised clause speaks to awareness or reasonableness to be aware. So it's there, it's captured. Just look at 9.1a and
No,
B,
9.1b.
9.1b. Being a public official, as soon as a public official becomes aware of or would be reasonably expected to be aware of the holding of interest. So it is captured. So it's not?
It's not captured at 9.1.
You have your hand up. Go ahead. Let me hear from the SG.
It's not captured in A, it's captured in B. But I was going to suggest something else for the committee to consider, to put in a defense. So if you put in a defense to say that that the person would then be put to prove that they did not know and could not have reasonably known, and that is something that we do in some laws as well, especially when there could be some element of unfairness, because it is being recognized that there is that possibility that the person really does not know, but then this whole thing about could reasonably be expected, it's from my perspective, it's a little vague for a criminal offense. So I would suggest that you perhaps look at putting in a defense, because then it's not just that it automatically is triggered, the person would be put to prove.
Well, but wouldn't implicit in what is said there in B that reasonably expected would require some sort of response or no?
it's different if you actually provide that person with the ability to provide a defense, and you put it in the law so that it is something that would be recognized in court, that they could then mount a defense based on that particular point.
Okay. But, I mean, I have no issues with that if that is kind of a
Sure.
best practice and reinforces the fairness of the or reasonableness of the legislation. Mr. Edwards, you want to comment on that?
I was just saying, Chair, that is what the Solicitor General has indicated is exactly what was our initial response to Senator Golding Campbell's concern, the possibility of creating a defense. So we are consistent on that point, Chair.
So what Solicitor General would be saying then, therefore, is to apply the burden of proof on the individual to say, I have to now prove that I was never aware or was not reasonably expected to be aware. Is that what you're saying?
Sorry.
Yes, because there is case law that says that if facts or certain material is particularly within your own knowledge, then it's okay for the onus to shift to that person.
To you?
Yes.
Okay. Now, Chair, I believe where we started was to determine if all of 9 between 1 to 7, if there's the application of it being a criminal offense. But when I look at the various ones, they are different in nature. They are not similar in terms of the actions that would be applicable to a charge. And since, in my mind, this is a first approach to a legislation, I don't believe that it should rise to the level of a criminal offense, but more civil in nature, approaching disciplinary actions. Yeah? And because we have all of them in one rubric between 1 and 7, and they are different in nature. Because, the first set speaks to awareness. But when you look at like 6 and 7, it's the possibility of money passing hands, which is of a different nature. And so we can't have all of them in one rubric, and then we are going to propose that they should be of a criminal nature in the first instance. So I'm more for disciplinary actions.
Okay. Senator Golding and then Senator Daly.
Chair, I make one last advocacy on this point. I'm not supportive of treating the two categories of employees differently. I don't see why we would do that. Or maybe I should ask, what is the policy basis for doing that? In 9.1a, we have the person who is just beginning the employment. In 9.1b, we have the person who is an existing employee. Why would we cause the person beginning employment to face a sanction and have to defend themselves when in 9.1b, we can only go forward with sanction on the awareness element? I don't understand why we would treat them differently.
Yeah, I believe Mr. Edwards had commented on that. Mr. Edwards, you want to refresh us all?
Yes, Chair, that the ministry is quite willing to harmonize the approaches between both. So it wasn't intended to be as a policy distinction between the person coming in and the person already existing as a staff member. So we can harmonize the language to ensure that the same test applies to both.
Okay. All right. So I'm going to get back to the measures. And Senator Gale made a submission which I'm inclined to support. Are there any, if you are inclined to, if you have an objection, then we can hear what you have to say, members. Otherwise, I'm assuming silence means support to what Senator Gale said. I see no hands up, and I'm giving a few. Oh, Mr. Edwards, your hand is up. Go ahead.
Yes, but not an objection, just a clarification, Chair, that we hear the term disciplinary penalty and rules being used, but what is being proposed is not disciplinary, because disciplinary relates to the disciplinary process in your organization. What we're talking about is just broad civil penalty.
Yes, yes.
Okay, I just want to clarify that. Thank you.
Just for clarity, Mr. Edwards, in this case, who would take out this civil action? Against whom?
Well, this is a question, because it can be that you provide for a penalty that of course, it should be going before a judicial body, a court, but it would be a matter of determining whether the penalty is going to be paid directly into the consolidated fund or to any other public funds. But because we don't have we haven't set up an authority or fund in relation to this matter. So it would be speaking to a civil penalty to be imposed by a judicial body, by a court, and it will be paid most likely into the consolidated.
I'm sorry, let me yield to you. SG.
Right, so in other jurisdictions, you have this concept of administrative penalties. I know Mr. Edwards referred to the Building Act, but in the Building Act, you have local authorities, and it would have been those authorities, and you would have had to have the penalty fixed in law because of our constitutional construct, because of new issues arising out of Section 15 of our Constitution that deals with compulsory acquisition and taking of property, which includes money. Generally, you would have had to have something. So in our jurisdiction, we usually have, if it's not a criminal offense, it's gonna, well, usually with the criminal offense, you have a fixed penalty option, but that usually is still linked to a criminal offense for the most part. Where you may have this other option is where you have, let me call it a regulatory body. So like, for instance, under the Building Act, you had the local authorities who are, for instance, your municipal corporations and so on. I know under the Legal Profession Act, the General Legal Counsel, the disciplinary committee, also has been given that power, although that predates the new charter, so you don't know what can arise from that. But generally what has been accepted before is if you put fines and the legislature fix the fines, it's fixed. So you don't have somebody determining what the fine is because that person is not a judicial authority. I heard Mr. Edwards then also, but he said that it would go before a judicial authority, so that would mean a court. So it could be then that you are putting fines and not a custodial sentence. And you could put the option like what you do in road traffic to say that these are not, pleading guilty would not make you subject to having a criminal record. Because you have that in like the road traffic and so on, where you pay a fine for certain offenses and it doesn't attract a criminal record. So that could be the option that you're looking at.
So, Mr. Edwards, what are you recommending? Go ahead, your hand is up.
Yes, Chair. Well, this is, as the Solicitor General has been doing, these are some of the issues we were wrestling with, and we decided that it would be best for it to be ventilated in committee as is happening now. And we brought to the Building Act, which of course is a post the new charter, so it's current, but of course the Building Act, as SG has indicated, refers to the local authority as the body that will handle these issues. We don't have such a body in this legislation. So we are okay with an approach that specifies an amount or refers to a prescribed amount being imposed, and yes. So we're okay with such a scheme, a prescribed amount as a penalty being indicated. But our concern was that we wanted to make it very clear that there would be a distinction between either criminal or a civil sanction. We didn't want.
I think we have established that.
Yeah.
So the question is.
The question in my mind now: who would be the enforcer in this application? What authority would so do?
Well, we have provision for authorized officers because this is something that would be a result of some investigation or enforcement activity. So we do, the law does provide for authorized officers to be the enforcement arm under this legislation, but there could also be further development of that process.
What I would suggest, Chair, is that if that is the application that we are now pursuing under these deliberations, then Mr. Edwards can flesh it out and represent it at a later date. Because anything that applies sanction is critical, and there has to be that scope of permissiveness that is so detailed in nature that people can understand what they are getting involved with and what are the particular consequences that they are going to face. Whether or not it's these enforcement officers fall under the Ministry of Health or things like that.
Well, I think that now that we have taken a decision, which seems to be what Mr. Edwards' posture was, that he takes to us the issue around criminal sanctions as opposed to civil sanctions, and there appears to be a general consensus around civil. The next step would be to determine how that can be manifested or applied. Am I correct in saying that, Mr. Edwards?
That is my understanding, Chair. Yes.
Right. So I take the suggestion by the Solicitor General or the options that she has laid on the table. And what I would do then as a decision is that you now move to the next level, given a decision, and work with the Solicitor General if necessary to kind of work out some proposals that will be taken to the next meeting, including some of the possible amounts. And find some sort of precedent or established benchmark that we could imitate. All right? I see Dr. Guy's hand up. Dr. Guy?
Just a quick question, Chairman, to Mr. Edwards or to the SG. The talk is about civil sanctions. Administrative sanctions are civil, right? So it would be administrative sanctions then that we're dealing with as a form of civil sanction.
Yes, the term civil sanction, and of course, I yield to the SG for further elaboration. But what we really meant to say was that it would be a financial penalty, like a pecuniary penalty. That's what we are referring to when we.
Why I asked because civil could also mean going to court, civil court, you know. So
yes.
This is for clarity on my part.
But that probably would occupy your mind now that we have agreed on the approach. So, Mr. Edwards, can you take that on, and when we meet again, we have some proposals around that, and why?
Yes, thank you.
Okay.
Thank you, Chair. No,
right, can you move on now, please, to the next?
So the next provision.
Sorry, I just want to be clear that members have agreed to the approach, read clause 8 and 9. I'm assuming that we have, but I just want to place on record so that we don't need to go back because when next we shall meet.
Yes, Chair.
Okay. All right. I see no disagreement. Okay, Ms. Edwards, continue, please.
Okay, Chair. The next provision would be clause 10. And again, this is the one relating to disclosure of in relation to a person who has left the industry or proposes to work in the industry. This basically disclosing your connections either with the tobacco industry before you're seeking to be employed, or for somebody who has been employed in the public service to inform the appropriate public body where the person had served about their intention to engage in occupational activity. Essentially, your intention to work within the tobacco industry within after the expiration of 3 years, because basically there's a 3 year what should I call it, restriction period that no public officer, no specified public officer would be expected to begin working with the tobacco industry. But after that period, you can. But you're expected to inform your former employers in the public service of your intention to work within the industry. And that is whether you're going to be paid for your activities within the industry. The question is whether that should attract a criminal, whether it should attract a sanction at all. So why we highlighted this is because we had not made provision for a sanction, and therefore the question to the committee is whether this issue of disclosure of your connections with the industry, either when you're coming in or going out, whether this should attract a sanction. This is what is being put to the committee chair.
Okay, members, I think we could probably proceed along the lines of the previous clause, but let me hear what members have to say. I mean, we've established a kind of approach, so we could probably do the same and then learn and then be guided by what you come with next time in terms of the extent of the sanctions, civil sanction. What
Here.
members? Yes.
Here. I see the point here and the question and the comment you made about a civil sanction, but how would that be enforceable? Because the person would no longer be employed. How could I get a roadmap as to how that could be enforced?
Well, the roadmap is coming next time, and the same approach.
No. I understand that, Chair, but this particular one, we have to be careful in terms of trying to make a sanction, which is not possible or might not be possible.
Why wouldn't it be possible if
the person is no longer in the employ of that public body?
But is the sanction coming from the public body, or is it from the authority that is designated as the enforcement authority? That's my understanding, which is what they will come with next time, and that same authority would carry that role in terms of enforcement. Mr. Edwards, you want to comment on that?
I'm just going to say briefly that this is not dependent on somebody still being in your employ or not. It's just a matter of the facts that the authorities are made aware of, that X was employed with the ministry in this capacity, and 2 years later, they're now employed to a tobacco company. And the person may be called in to explain the circumstances. And if they cannot properly do so, then a charge or a complaint can be made against them. So it's not dependent on whether they're still employed or not.
Just quickly, why 3 years?
No.
I think that we had discussed that as a reasonable time for any kind of advantage to be exploited would dissipate. It's like buying a business and then going in the same business. Normally they give a time for no competing interests. You not being a competitor with the business that you have sold within a period of time, because you could take all the clients and basically leave the business as a shell. I think that's the same idea, but I see, you want to comment? Why don't you sit in front of a mic, yeah.
I wanted to also mention that for reference, we've seen the same provision in at least 2 other Commonwealth jurisdictions. So we're looking at Kenya and Uganda because those models seem similar to ours. So again, this provision is not one that is new or unique to Jamaica.
Are they
But a
criminal
more
or-
rational explanation is just the sort of timing. Yes, yeah.
Criminal. If I may continue on that line, Chair.
Hold on,
Yes.
Mr. Edwards. I have a comment here from Member Gale. Member Gale?
So when you look back at the provision, and I can understand this grace period to which engagement or a declaration, but for some clarity, Mr. Edwards, whether gainful or not, more or the or not, what does the or not refers to? Because is there a pecuniary advantage to the or not? I can understand if you have some gainful advantage within the period, but what does the or not represent?
Represents the
Yes,
opposite
Chair.
of gainful in this
And I'm glad-
instance.
yes.
Mr. Edwards, you want to explain?
Yes, we are glad that it has been brought up because there can be usefulness to the operations of the tobacco industry by persons acting in voluntary capacities. You can be a member of a foundation that is supported by the industry. You may not be paid for your activities. You may have a position that is unpaid, but it's still very influential. So this is why we did not want to just leave it to somebody who is a paid employee, because you can actually have much more influence as an unpaid person, certain position.
Is that reasonable?
I don't know if it's reasonable if you're going to say, I'm going to get an umbrella that says a brand or of marketing. But I hear you, Mr. Edwards. I think it has some merit to it, whether or not, again, such action would be one of a criminal nature.
Well, I think we have concluded on that.
Oh, yes. We're treating it on
yes,
the same principle.
Yes, on the same principle.
All right, that's fine.
So it shouldn't, yeah, okay.
Get a fine for we're
All
walking with an umbrella.
Mr. Edwards, you want to continue, please?
All right, so should we make a jump now to the provisions relating to protection of children? Because there was concern expressed about that in a number of respects. So first of all, in 15, we're going to clause 15. So now a provision is being, an offense is being created in clause 15. I'm just trying to make sure that I'm looking at the several documents. Yes. So we are now creating a new offense in clause 15. We've had to do some renumbering. What is now 15.3 is going to become 15.2. And this is relating to the sale, putting up the signs that you're not supposed to sell to a child, etc. Tobacco product or relevant product. So provision is now being made for an offense that is not a fixed penalty offense. There was concern that these matters in relation to children, one should not just be able to get a discounted penalty and be gone. So no provision for fixed penalty. It's now provision in the 5th schedules, and the graduated set of penalties will apply in relation to this issue of signage no smoking. Then there is also the matter, and we also want to indicate that this is not in conflict with the Child Care and Protection Act. The Child Care and Protection Act, Section 40, makes provision in relation to breaches by establishments in relation to children. This, however, is of a more general nature in relation to matters like protecting children from influence, whether by signs or exposure to sale of tobacco products. So there's a distinction between the provisions in the Child Care and Protection Act and what is being proposed in this legislation. That's 15 up to that point. But yes, so that's in relation to 15, Chair. I don't know if there are any comments from the we also wanted to indicate, Chair, that there was concern about persons who habitually commit offenses in relation to not protecting children from exposure to tobacco products or being involved in the sale of products. So, or being our institutions not indicating clearly that tobacco products or other relevant products should not be sold to children. The provision is now being made that all those offenses will attract graduated penalties, meaning that for the first offense, second, third, the penalty rises. So therefore, the whole issue of persons being repeat offenders, they'll be repeat offenders, but at a higher cost each time. So those are the changes in relation to Clause 15, Chair.
Thank you, Ms. Edwards. Any comments from any member? No comments? Okay.
No comments from me, Chair. I'm good with what I'm seeing. Thank you.
Okay. All right, so can we agree then that we will proceed with what is being recommended in Clause 15? I'm assuming silence means consent in this instance.
Just to find out, how do you treat the vendors on the roadside in terms of accountability, especially in terms of the child care and protection, and also some of the shops too, who have to sell these children. You don't know who is using it after that, so it's a little bit vague. I'm not too certain how we would treat that in order for us to be able to enforce.
Mr. Edwards?
The basic, in response to Senator Daly, Chair, the basic prohibition is against supplying a tobacco product or relevant product to a child. And child is defined as a person under the age of 18 years. So in relation to the person on the roadside, for example, the sale of tobacco products, we recognize that there are going to be a range of sellers and suppliers. So this is why members will note that the range of penalties starts from a relatively small amount. I think it's 5 or 50,000 maximum, because it's recognized that there are going to be the very small vendors who could be found to be in breach, and it will be for the courts to judicially determine what is an appropriate penalty in those cases. So there is some acknowledgement that there would be a range of, from the very small, man or woman on the street to the large retailer. So that is taken into account in how the penalties have been proposed here.
Are you okay, member? Yeah, okay. All right, so can we move on then to the next clause, Mr. Edwards, which would be
Clause 19, Chair. Clause 19. Clause 19.
19,
which
yes.
is the one dealing 19 prohibition of sale in certain places. So we have made provision in subsection, well, proposed in subsection 2 that the new fifth schedule, the fifth schedule has a set of graduated penalties. And this would also allow for the whole issue of recurring offenses in relation to children to be addressed. It would address the matter, I think it was described as continuous, intentional, or negligent exposure. That was the language that was used by one of our members or stakeholders in relation to children. So that the fact that in subsection 2, we provide for the fifth penalty schedule to apply, there will be graduated penalties as if one is a recurring offender. That's the only issue, Chair, in relation to that provision.
Okay, thank you. Any comments, questions by members? I think that's fairly straightforward. None?
Chairman.
Glad to see the amendment, Chairman.
Oh,
Chairman.
yeah, member Guy, go ahead.
Thank you. Mr. Edwards, can you point out where the concern is, or it didn't come up here, or we have already settled that on the protection of children, that there is, I mean, I've seen you've crossed out a child, person shall not supply electronic non-nicotine device system to a child. Where is it that we have any tobacco or tobacco products to a child and the sanctions?
It's in 19.1, 19.1. Sorry, 15.1. 15.1, clause 15, subsection 1.
Oh, okay. All right. 15, let me just refer to my bill here. 15. All right. Okay. Okay. Mm-hmm.
Okay, thank you very much.
And the sanction for that?
The sanction for that, let me look at that. 15.
15.1. Okay. Yes, it's at there.
Yeah.
Person who contravenes subsection 1 commits an offense. But that's 19. Where's the sanction for 15.1?
Yeah, 15. I'm going to 15.
Oh, that's 4 then. 4, yes. A person or a seller who contravenes the provision of subsection 1 commits an offense and shall on summary conviction. All right. Okay, thank you. Thank you, Chair.
That's it.
Thank you. Thank you very much. Any other comment? No? Okay, Mr. Edwards, you want to move on to 19? Oh, you finished with 19?
I think I finished with 19, sure.
Right. Okay, can you move on then to the next?
Moving on would take us, Chair, to the new clause 37. I don't think there's anything before that. No, nothing else new.
What about 24?
A, which is the one. There's nothing new yet. There's nothing new there, Chair. There are matters to be discussed, but in terms of new, the only new thing that has happened is that in 24.1, we kept the language as it was. There was a proposal to make a change in the language, but that change would have been in conflict with the definitions of advertising and promotion and the definitions of tobacco sponsorship. So that would have been the only change to 24. There are other issues in relation to 24, but we haven't changed the language of 24 at this point.
Okay, proceed then.
24 still provides for a prohibition on advertising and promotion and sponsorship.
All right, proceed.
So there's actually not a yes. So now in relation to further changes proposed, this is 37A. This is a new provision that would allow for guidance to be issued or directions to be issued to public officials. As we had said earlier, none of the earlier provisions is making a specific link to the regulations that govern public officers in relation to application of sanctions. But this now, and this is not a sanction provision, this is a provision empowering the Minister of Health and Wellness, who has portfolio in this matter, in consultation with the minister responsible for the public service, to issue guidance or orders to public officials. And these would basically guide them in terms of how they carry out their functions in light of the proposed legislation, how they will conduct interactions between themselves and industry as may be necessary, and such other matters relating to tobacco control as the minister may prescribe. But this is where some of the issues that have been raised earlier in terms of notification and how these procedural steps that should take place. This document could be where such matters of detail in terms of process are addressed, Chair.
Okay, so do members have any comments on? So this essentially is empowering the minister to direct, if you will, any amendments or adjustments to particular circumstances.
It's giving the minister the power to, right, to give the detailed procedural steps in relation to these matters of interactions, etc.
Which is relatively.
But it's not a sanction.
It's relatively. It's standard, right? Would you classify this as relatively standard?
I wouldn't say standard. What I would say is that it's similar to an organizational, what we would call, you look at like an organizational manual. It's basically like your organization manual for tobacco control. That's what it would be. Yes.
Yes, member.
I would ask Mr. Edwards to define and determine whether or not these guidelines would form part of, in the first instance, a regulation or supporting the regulation, or take, for instance, in the sexual harassment legislation, you would have some sort of a guideline, code of guideline that is presented to the employer. In this case, the entity managing this, would it be the Ministry of Health or the ministry with responsibility for the public service?
As it is framed, as it is proposed, it will be the Ministry of Health.
The Ministry of Health.
But in consultation with the Minister for the Public Service.
Okay.
Yeah.
And so these guidelines now would be specific in nature. You have one that speaks to a code of conduct. I mean, there can be different guidelines, correct?
Yeah. Yes, it's the matter of how it is going to be styled, how it is going to be named. We didn't want to fix a name to it. Yes. But it would essentially be supplementing existing guidance to public officers. So, for instance, this would become something that would be supplementary to, for instance, the staff orders. So somebody entering into the
staff
public
orders, similar in nature.
Yeah.
And
it will be similar.
The staff orders are very specific, you know.
That's what I'm saying, and this is very specific. This is just a supplement in relation to code of practice in
you may want to say that this is a code of conduct specific in relation to this legislation? I would
yes,
want it to be aligned or to be associated with any other. And it ought not to be represented with the staff orders, because that is clearly defined and specific in nature.
Yes.
And
yes,
then what would be the seventh schedule now?
The seventh schedule will contain the details of all the steps in relation to matters of process. So, for instance, this whole issue of when you notify your supervisor or what you notify your supervisor of, it may even provide for prescribed forms for notification, all those details. The issue of if your meeting, your intended meeting with industry didn't take place, it could provide for notifying in the event that a meeting doesn't take place, notifying within a certain period of time that the meeting didn't take place. All those details could be put in the guidance.
So you, at some point in time, would be preparing this for our line of sight, I assume?
Well, we had shared earlier through chair, to you, chair. We had prepared and submitted a sample, which actually sample of a similar type of document that operates in Australia. So there are precedents of this type of guidance note. Yes, but we would be developing one appropriate for the Jamaican Public Service, if the committee so accepts.
I can only accept it, Mr. Edwards, when I see it.
Right.
Yes, but as I said, we had set a precedent. We had sent a precedent.
Well, I have to really look back at that. Then.
Yes, look back at it, and
if I can find it,
we would have concluded on the report. All will be included. So, but yeah, check that back, and if you need any clarity, we can follow through on that. You had your mic up, SG.
Thanks. I'm just wondering, though, if this needs to be elevated to regulations, because these are basically regulations. When you say you call them orders or directions, they're going to be prescribed by the minister by order, and they're gazetted. These are basically regulations. I'm not sure that you want to elevate your code of conduct to actual regulations. You can have generally, more frequently, the usual process for codes of conduct are to provide guidance, but they're not elevated to the status of regulations. In the financial sector, you will have things like guidance notes and so, which are elevated for you can understand why. I'm just not sure that you need to elevate these to regulations, and if you were, then you didn't need to separate them from your regular regulation-making powers. But I thought this was going to be sort of more discreet. Whether you call them guidance notes, whether you call them codes of conduct, which we have in different laws like MOCA, we have code, and even in the sexual harassment, although I think that may have been elevated a little bit. Can't recall in the sexual harassment. I'd have to look back at it. I'm just thinking that maybe this is something you want to consider.
Yeah, I get the point.
Mr.
Edwards, is that, are you receiving that?
Maybe I'm saying that we don't necessarily want it to be regulation, but we did want it to be at a level that would be, I don't know, there's a halfway point, but we wanted it to have sufficient standing of seriousness, but not necessarily as another law, as another tobacco law. No. So that's why we are using language of guidance notes as opposed to regulations. But I hear what SG is saying, Chair, and we can see if we can make any tweaks with the approach so that it's clear that it's not regulations, but it is something that would be considered if there are breaches of it.
All right, let's do that. Let's do that to get the kind of consensus, because I think it's there, clear and plain, so it doesn't, I don't know if it changes much, to be honest, so let's not disagree too much around that. All right, Mr. Edwards, can you move on now if we are agreed to the schedule? I think that's where we are, right?
Indeed, Chair, that's where we are. So in terms of any adjustments, any new areas, the fifth schedule.
Before though, can I just get a confirmation on the new provision to ensure that we're all agreed? This is 37A. New provision after clause 37, or for the inclusion of 37. You're okay? I see any objections, any comments? No? So I'm assuming we're all agreed. All right, Ms. Edwards, go ahead.
Yes, I'm going to the fifth schedule, Chair, and the changes would be consequent on decisions made. So if clause 9 is not going to be a criminal sanction, then the proposed language there that applies to clause 9 in the fifth schedule will be taken out. Those words in relation to section 9 would have applied if 9 were to be criminal sanction. So we would make adjustments accordingly, taking out any offense creating provision in relation to clause 9. The next, Chair, any comment on that?
No, I see no hand up, but I have none, so proceed.
Okay. Yes. And then the next change would have been in relation to 19.2, selling tobacco products in certain places. And this is yes. This is creating again graduated penalties in relation to the sale of tobacco products in certain places, and this would apply to the educational institutions, etc., and address the concerns of those who are concerned about repeated offenses that would affect the interests of children or vulnerable persons such as children.
Mr. Edwards, 19.2, and what you have in for an individual, a fine of 50 in bracket and then $500,000. What are you seeking to represent?
Sorry, thank you. It was because there was a question of where we should begin with the first offense. The ministry the ministry was making a proposal as to whether the first offense should actually have an upper limit of 50 rather than 500. This was because of the concerns of this particularly small sellers, and if you started at 500,000, it may send a particular signal. Maybe it's a question of whether the committee is okay with 50 or whether we should find somewhere in between as a starting point. But this is the individual, not the corporate reach. This is for the individual seller. So that is why it was still in square brackets, Chair.
Oh, okay.
Okay. You're good. Continue, Mr. Edwards.
In relation to the fixed penalty provisions have been changed to take out the fixed penalty offense in relation to not putting up proper signage of no smoking, not selling to children. So that was taken out of the sixth schedule. No longer can you just pay a fixed penalty and get off. It will be subject to full criminal sanction if you do not put proper signage in relation to no sale of tobacco products to children.
Okay, thank you very much. Any comments? Are we agreed on the schedules or the path forward? Any comments, concerns, questions? I see none, and I am assuming that means consent, agreement. All right. So I think we're completed another lap. Thank you very much to all. Can we move then to any other business on the agenda? Well, the process, okay, any other business, what next? Maybe that's a good question. I'm told that we will now engage or await a report that we will need to allow a few weeks. A few weeks sounds reasonable. Give or take a few days, a few weeks, and then we will reconvene to review that report. And that looks like after the Christmas break, after the holidays. And hopefully then in January of 2024, which is not too long from now, even though it sounds distant. And then having reviewed that and agree, we will then move to tabling.
For notification, Chairman, I would love for you to let us revisit the fines in our next meeting.
Yes, at the next when we're looking at the draft report, just to, we can look at that. All right, so I think this has been a journey, but it signals the end of another chapter with one or two other chapters to come. So I would like to use the opportunity. First of all, I don't think we need to set a next meeting now. So let's await the end of the report, and then we'll notify persons of a proposed meeting date for the new year. And I would like to use the opportunity, given that this is likely to be the final meeting for the rest of this calendar year, to wish my colleagues the very best. I would like to thank all who have participated. I think that we have all engaged the process in a sincere and spirited in some instances, but with a similar objective of trying to get the best in terms of the legislation. And I want to express my sincere appreciation to every member. To Mr. Edwards, who has had to lead the charge to a large extent, I want to thank him. The job isn't done yet, so I hope I'm not sounding like his eulogy. And to this SG and her office, thank you very much for your ongoing and consistent input, which has led to some adjustments which we appreciate. And to PAHO, of course, the ministry and the parliamentary team here. So thank you very much. Enjoy your break, well-deserved break. And I want to say to the people of Jamaica, we continue to press ahead to get this legislation out in the interest of all concerned. Having said that, I'm now on item 10. So moved. Member Daly, seconded by Member Gale. Meeting is now adjourned at 4:27 and 42 seconds. Thank you.
Size matters. Evidence shows that bigger is better when it comes to graphic health warnings on tobacco product packages. The effectiveness of health warnings increases with their size. The proposed Tobacco Control Act requires that graphic health warnings cover at least 80% of the principal display areas of the tobacco product. By implementing larger warnings, Jamaica will join a growing number of countries that have adopted such laws. The right of governments to require large graphic warnings has also been upheld in many cases, as various tribunals at the highest levels have found that the size did not interfere with the company's ability to use their trademarks. Larger graphic health warnings under the proposed act will reduce appeal, consumption, addiction, and protect the nation's youth.
Virgin, The road signs make the traffic environment